Hello students, welcome to the lecture on industrial disputes and discipline. And after this lecture we'll be able to learn the following objectives. Explain the concepts of disputes. Define the concepts and nature of industrial dispute. Discuss the forms of industrial disputes. Understand the industrial dispute causes. Define the dispute resolution. Describe the meaning and techniques of conflicts. Explain the meaning, objectives, and approach of discipline. Understand the maintenance of discipline. Discuss the causes of indiscipline. Let's start with some introduction first. Industrial disputes are organized protests against existing terms of employment or conditions of work. According to the Industrial Dispute Act, an industrial dispute means any dispute or difference between employer and employer, or between employer and workmen, or between workmen and workmen, which are connected with the employment or non-employment or terms of employment or with the conditions of labor of any person. Let us first discuss about the concepts of disputes. Disputes in the workplace between employees and employers, or indeed between employees and their colleagues, inevitably happen from time to time. They can arise out of a whole range of circumstances, including, but not limited to, simple misunderstandings, or mistakes, poor communication and decision-making, tensions or personal difficulties, breaches of trust or of the law, infringements of personal dignity or human rights, inability or unwillingness to perform allocated work, unacceptable behavior, and so on. Employee self-esteem, morale, and productivity can be harmed, as can their longer-term employment prospects. Negative effects on business productivity, reputation, employee motivation, and workplace relationships can also be expected. Disputes carry costs in both monetary and psychological terms. Disputes, nonetheless, are a fact of life. They will always occur. Not all can be prevented or avoided. Let us now understand the concepts and nature of industrial dispute. The consequences of an industrial dispute will be harmful to the owners of industries, workers, economy, and the nation as a whole, which results in loss of productivity, profits, market share, and even closure of the plant. Hence, industrial disputes need to be averted by all means. Prevention of industrial disputes is a proactive approach in which an organization undertakes various actions through which the occurrence of industrial disputes is prevented. Concept. Industrial disputes are organized protests against existing terms of employment or conditions of work. Nature. An industrial dispute may be defined as a conflict or difference of opinion between management and workers on the terms of employment. It is a disagreement between the employer and employee's representative, usually a trade union, over pay and other working conditions, and can result in industrial actions. When an industrial dispute occurs, both the parties, that is, the management and the workmen, try to pressurize each other. The management may resort to lockouts, while the workers may resort to strikes, picketing, or guerrero. The disputes generally arise on account of poor wage structure or poor working conditions. This disagreement or difference could be on any matter concerning the workers individually or collectively. It must be connected with employment or non-employment or with the conditions of labor. Let us now understand about the forms of industrial disputes. Strikes, lockouts, and guerrero are the most common forms of disputes. Strike. Strike means a cessation of work by a body of persons employed in any industry acting in combination, or a concerted refusal, or a refusal under a common understanding or a number of persons who are or have been so employed to continue to work or to accept employment. The following points may be noted regarding the definition of strike. Strike can take place only when there is a cessation of work or refusal to work by the workmen acting in combination or in a concerted manner. A concerted refusal or a refusal under a common understanding of any number of persons to continue to work or to accept employment will amount to a strike. If on the sudden death of a fellow worker, the workmen acting in concert refuse to resume work, it amounts to a strike. The striking workman must be employed in an industry which has not been closed down. Even when workmen cease to work, the relationship of employers and employees is deemed to continue, albeit in a state of belligerent suspension. Types of strike. Stay-in, sit-down, pen-down strike. In all such cases, the workmen, after taking their seats, refuse to do work. All such acts on the part of the workmen acting in combination amount to a strike. Go slow. Go slow does not amount to strike, but it is a serious cause of misconduct. Sympathetic strike. Cessation of work in the support of the demands of workmen belonging to other employer is called a sympathetic strike. Hunger strike. Some workers may resort to fast on or near the place of work or residence of the employers. Lightning or wildcat strike. A wildcat strike is an unofficial strike. Example, a strike not sanctioned by the union. Work to rule. Since there is no cessation of work, it does not constitute a strike. Economic strike. Under this type of strike, labor stop their work to enforce their economic demands, such as wages and bonus. General strike. It means a strike by members of all or most of the unions in a region or an industry. It may be a strike of all the workers in a particular region of industry to force demands common to all the workers. Regulation of strikes. Strikes would come under the classification of collective disputes. The forum for their resolution is the industrial court. However, unlike in England or the United States, where the immediate remedy to break a crippling strike is the controversial labor injunction, there is no provision under the Act for the Industrial Court to grant injunctive relief. A national strike, which threatens an industry or cripples an essential service in the country, would never be allowed to run its course. It declares that workmen shall not go on strike after a trade dispute involving them has been referred to the court. Strikes can occur because of the following reasons: dissatisfaction with company policy, salary and incentive problems, increment not up to the mark, wrongful discharge or dismissal of workmen, withdrawal of any concession or privilege, hours of work and rest intervals, leaves with wages and holidays, bonus, profit sharing, provident fund and gratuity, retrenchment of workmen and closure of establishment, dispute connected with minimum wages. Lockout. The Industrial Disputes Act defines lockout to mean the temporary closing of a place of employment or the suspension of work, or the refusal by an employer to continue to employ any number of persons employed by him. Lockout, thus, is the counterpart of strike, the corresponding weapon in the hands of employer to resist the collective demands of workmen or to enforce his terms. It has been held by the courts that the suspension of work as a disciplinary measure does not amount to lockout. Similarly, temporary suspension of work, called layoff, is not lockout. A lockout is a work stoppage in which an employer prevents employees from working. It is declared by employers to put pressure on their workers. This is different from a strike in which employees refuse to work. Thus, a lockout is employers' weapon while a strike is raised on part of employees. A lockout may happen for several reasons, unless the limited court appeal is made. It may be less formal in structure than going to court, depending on applicable arbitration rules. Usually quicker and less expensive than going to court. Types of lockout. Picketing. When workers are dissuaded from work by stationing certain men at the factory gates, such a step is known as picketing. If picketing does not involve any violence, it is perfectly legal. Pickets are workers who are on strike, that stand at the entrance to their workplace. The purpose of picketing is to stop or persuade workers not to go to work, to tell the public about the strike, to persuade workers to take their union's side. Regulation of lockout. Employees do not have an unfettered right to go on strike, nor do employers have such right to impose lockout. The Industrial Disputes Act lays down several restrictions on the rights of both the parties. A strike or lockout commenced or continued in contravention of those restrictions is termed illegal, and there is served punishment provided for the same. Consequences of lockouts. Penalty for illegal strikes. Any workman who commences, continues, or otherwise acts in furtherance of a strike which is illegal shall be punishable with imprisonment for a term which may extend to 1 month, or with fine which may extend to $1, or with both. Penalty for illegal lockout. An employer who commences, continues, or otherwise acts in furtherance of a lockout which is illegal shall be punishable with imprisonment for a term which may extend to 1 month, or with fine which may extend to $20, or with both. Gareo. Gareo means encirclement of the managers to criminally intimidate him to accept the demands of the workers. Gareo in Hindi means to surround. It denotes a collective action initiated by a group of workers under which members of the management are prohibited from leaving the industrial establishment premises by workers who block the exit gates by forming human barricades. Let us now discuss industrial dispute causes. The causes of industrial conflict or disputes have been much varied. These may be described partly as psychological or social and partly political, but predominantly economic. Some important factors responsible for industrial conflict and poor industrial relations, many are management's general apathetic towards workers or employees because of their contention that they want more and more economic or monetary rewards and want to do less work. Mental inertia on the part of both management and labor. Lack of proper fixation of wages in conformity with cost of living and a reasonable wage structure generally. Bad working conditions. Attempts by management to introduce changes, such a rationalization, modernization, or automation without creating a favorable to appropriate climate or environment for the same. Assignment of unduly heavy workloads to worker, unfair labor practices, such as victimization or undue dismissal. Dispute resolution generally refers to one of several different processes used to resolve disputes between parties, including negotiation, mediation, arbitration, collaborative law, and litigation. Dispute resolution is the process of resolving a dispute or a conflict by meeting at least some of each side's needs and addressing their interests. The dispute resolution process is a participatory and creative process and is required prior to filing a grievance to a decision maker. In the complaint process, the dispute resolution officer, as an impartial third party, will consult individually with us and with supervisor to gather relevant information. identify both of issues and interests, and explore options for resolution. Appropriate dispute resolution, ADR, as it is commonly called, comprises arbitration, mediation, conciliation, and negotiation. These time-proven processes are the alternatives to seeking settlement of disputes through the courts. Some of the benefits of using ADR can be completed quickly. Schedules to suit the parties. Confidentiality. ADR settlements are a private matter between the parties, and there is no public record. ADR is generally voluntary except where it is required by contract or by statute. Negotiation. Negotiation is a less structured form of ADR. The facilitator's role is to keep the parties talking and bargaining. The parties may be individuals or teams. The facilitator keeps record of party positions and points of agreement they reach as discussions proceed. The process can be lengthy, as in labor or sports negotiation. The facilitator will prepare a memorandum of agreement containing all of the points agreed. Mediation, the parties decide. A dispute resolution process in which the parties freely choose to participate and any agreements reached to settle disputes is done solely by the parties, without interference. The mediator is selected by the parties, and once selected, the mediator will arrange the mediation process. The mediator makes no decisions. Instead, he/she acts as a facilitator only to assist the parties to understand the dispute, provide structured discussion, and to help the parties reach a dispute settlement agreement. Government machinery. The Ministry of Labor and Employment at the center is the key agency for the policy formulation and administration in all the matters pertaining to labor. The state governments, with the cooperation of their labor departments, are responsible for the enforcement thereof. The Directorate General of Employment and Training, DGET, Office of Cheap Labor Commissioner, CLC Central, the Director General of Mine Safety, DGMS, the Director General of Factory Advice and Labor Institutes, and industrial tribunals are some of the agencies through which the central government discharges its functions related to framing of labor laws and settlement of industrial disputes. Did you know? During 1956 to 57, an alarming number of cases of violence and intimidation, strikes and lockouts were recorded. Arbitration. Arbitration is a dispute resolution process where the opposing parties select or appoint an individual called an arbitrator. Upon appointment, the arbitrator will arrange the process to hear and consider the evidence